Hello, everyone. I'm Tanya Rivero. Thank you for joining us. 3 years ago today, President Trump was sworn into office. Now we are 1 day away from his impeachment trial to potentially remove him from office. The president is charged with abusing the powers of his office by withholding military aid to Ukraine as a means of pressuring that country to investigate a political rival. He's also accused of obstructing a congressional inquiry into his conduct. Opening arguments in the Senate trial begin tomorrow at 1 p.m. Eastern. Today, the president and his legal team submitted a 110-page written defense against those charges. The four main arguments are as follows. The articles fail because they do not identify any impeachable offense. The impeachment inquiry in the House was flawed. And Article 1 fails because House Democrats have no evidence to support their claims. The articles are structurally deficient and can only result in acquittal. Meanwhile, Democrats are intensifying their demands for new witnesses to testify. House managers, led by Intelligence Committee Chairman Adam Schiff, are working today on the impeachment trial's opening presentation. Democrats want to hear from acting White House Chief of Staff Mick Mulvaney and his senior advisor Robert Blair, former National Security Advisor John Bolton, and management and budget official Michael Duffy. Democrats will need the votes of 4 Republicans, and so far only 3, Mitt Romney, Susan Collins, and Lisa Murkowski, say they would be open to hearing from witnesses. So let's bring in Ben Tracy and Jessica Levinson. Ben is a CBS News White House correspondent. Jessica is a professor at Loyola Law School. Welcome to both of you. Ben, let me start with you. Looking at the president's trial brief, what type of preview does this give us of his team's defense strategy?
Quite a good one. This is a 171-page pre-trial brief, and we learn a lot from it. First of all, it's really striking the tone of this. You really get a sense of the contempt and disdain of the president and his legal team for this process. Let me just read you a couple of words that are in the summary of this. They call this impeachment an affront to the Constitution. It's the result of a rigged process, a brazenly political act. They say that this should swiftly and roundly be condemned by the Senate in these articles, swiftly rejected. But in terms of their actual legal argument, they do lay out how they're going to go about that. On the first article of abuse of power, basically the president's defense is abuse of power is not a violation of law, and they plan to argue that an impeachable offense has to be a violation of established law. They say that abuse of power is too vague a term. It's open to the subjective whims of Congress. On the second one, the obstruction of Congress, the president's team is basically saying that the president was simply trying to protect the separation of powers. That is his constitutional right, and therefore that cannot be impeachable.
So, Jessica, the president's legal team is arguing there is insufficient evidence then to impeach on the one hand. On the other hand, they're saying abuse of power is not an impeachable offense. Do you agree with either of those points?
No, I don't. And again, it's almost impossible to do, but let's try and take the partisanship out of it and just look at the Constitution, the impeachment clause, and what the founders intended. If you look at that kind of bucket term that now we're also familiar with, high crimes and misdemeanors, it was not intended to mean that you have to hook a high crime and misdemeanor to a federal criminal statutory violation, in part because the federal criminal code just didn't exist at that point. But if you look at what the founders were really worried about, it absolutely was this issue of abuse of power. The founders talk over and over again about worrying that a president, a public man, will have a public crime, and that it will be something like using the office for your own personal gain.
It's interesting, Jessica, because they're not bothering to argue whether or not he abused his power. They're not touching that one. They're simply arguing that abuse of power is not an impeachable crime, correct?
Very interesting. And in fact, if you look at statements by the Trump defense team, that's not consistent with the beliefs that they had even during the Clinton impeachment. So the idea that abuse of power is not impeachable offense is something that the founders would just roll over in their graves. That's exactly what they're worried about, that there would be something that would happen in between elections where a public man, they keep talking about, would so abuse their authority, misuse the public trust, that you can't wait till the next election. So it's simply not true that this is something that wouldn't fall within the bucket of impeachable offenses.
So, Jessica, is it at least clear then that the defense team doesn't plan to make a case for absolute dismissal of the articles, or is there a chance they still might do that?
So I think that that's what President Trump would want, but it doesn't look like there's going to be a play here for an absolute dismissal, because I think that Senator Mitch McConnell, who has enormous power as leader of the Senate, really doesn't have the appetite for that. As you said, it's interesting that there doesn't appear to be an argument based on, no, he didn't do that, or that phone call didn't happen, or the words that you saw, those really weren't spoken. It really is a very contentious brief that's based on the idea that there's something fundamentally flawed, that there's something that fundamentally lacks integrity with this impeachment inquiry.
Okay, let's also bring in Nicholas Wu now. He just joined us. He's a politics reporter for USA Today. Welcome, Nicholas. So opening arguments begin tomorrow at 1 p.m. Eastern. Set the stage for us. What will we exactly see taking place as this trial opens?
So as the trial opens, we'll expect to see debate on the rules for the very first stage of the impeachment trial. We don't quite know what those look like yet, but Senator McConnell has said that he plans to mirror the rules for the opening stages of Bill Clinton's impeachment trial a little over 20 years ago. So that'll be about 24 hours of debate for the prosecution and 24 hours of debate for the defense. What remains to be seen, though, is exactly over how many days that debate will occur. Will it be 24 hours over 3 days, 24 hours in 1 day? That remains to be seen.
So, Nicholas, Democrats, of course, are intensifying demands for witnesses and evidence to be included in the trial. But as we've been discussing over and over, at least 4 Republicans have to vote in favor. Is that looking likely? I mean, let's do the math for a second. We know that there are 3 Republican senators who have expressed at least some willingness or interest in hearing from witnesses. But have we heard from all the senators, including those who are perhaps in swing districts, moderate swing districts, where their seats may be in danger?
Well, it's kind of interesting. Some of the senators have said so far that they want to vote on witnesses after the very beginning of the trial begins. So that will be after they hear from the opening arguments from the prosecution and defense. So what we might expect to see is for swing state senators to vote no on witnesses tomorrow, but perhaps yes later on. Some, like Senator Mitt Romney, for example, have taken that position.
All right. So, Ben, how is the White House then preparing for the possibility, because it's not out of the question, that there will be witness testimony?
Yeah, the president's legal team is definitely preparing for that possibility. The White House does not want witnesses. They don't think it's necessary, and they don't want to drag this trial on. And obviously allowing witnesses or new evidence is one way to ensure that this goes on for weeks. The White House position on this is that the Democrats had their chance in the House to call these witnesses, John Bolton, Mick Mulvaney, and to get this evidence introduced on the record. Now, that is a bit more than a bit disingenuous, because the reason those people did not testify is because the White House refused to allow them to testify and did not provide a lot of documents that House Democrats were looking for. When we pressed the White House on this morning, senior advisor Kellyanne Conway said, well, it was up to the Democrats to take that to court, and they wanted to rush this, and they didn't bother to take the time to do it. It is now not the Senate's job to do cleanup for them. So that is the White House position. It was, you had your chance, you didn't avail yourself of all of the options to get a judge to force this testimony, and now we don't feel like we should just give it to you.
Right. So, of course, if Democrats do get their way, Jessica, it could push the White House and Republicans to demand witnesses of their own, as they've suggested in the past, like Hunter Biden. Is that a strategy you would expect if, let's say, the senators do agree to hear from witnesses?
Yes, I think so. I think that one thing I wanted to say, stepping back, is we're talking a lot about, whether or not what the president's legal strategy is, which facts he's going to argue. The important thing to remember is impeachment, of course, is a political process. So you can have a losing argument on the law. You can have a losing argument on the facts. But ultimately, the politics are the most important thing. So if you look in the Senate and you just count up the number of Republicans and count up the number of Democrats, That's, I think, the most important thing here. So
Sure.
when it comes to the strategy, though, of whether or not Hunter Biden, for instance, will be called, I think that is absolutely consistent with the Republican strategy that we saw during the congressional hearings, which is basically don't look over here in door number 1 of abuse of power or door number 2 of obstruction of Congress, but look over here in door number 3, which is Hunter Biden and Burisma and all of this corruption, which frankly may be true, but is completely beside the point of whether or not
Jessica,
President Trump is engaged.
So, Jessica, to that point,
Yes.
could Chief Justice Roberts then say, you know what, we're not going to hear from him because this isn't relevant?
He could. 2 caveats. 1, the Chief Justice, which he's not at all used to, could be overruled by a simple majority of the Senate. And 2, I think the Chief Justice is hoping, basically, if he could walk into Senate chambers, put a paper bag over his head, just drink through a straw, that would be what he prefers. So is he going to try and overrule what, the Senate Republicans want to do? I think that's highly unlikely. That's not the personality of this particular Chief Justice.
So you're saying that Chief Justice Roberts would rather be a fly on the wall than make his presence too known during this trial?
I think he would prefer to be a fly watching via teleconference another fly on the wall, yes.
All right. So, Nicholas, if the Senate does not allow more witnesses or evidence, which seems to be the way things are going if we're realistic, do Democrats have any recourse?
Not really. If they vote not to call witnesses and if they vote to move the trial along as fast as possible, we could see a very short Senate trial. This is unlikely, but the Trump administration officials have said that they do want to finish the impeachment trial by the State of the Union at the very beginning of February.
All right. Well, Ben Tracy, Nicholas Wu, and Jessica Levinson, thanks to all of you for joining us.
Thanks.
Thank you.